real staff use of the notes function in Odyssey eCourt system. So I'll first ask Nicole for an overview.
So I'm gonna be really brief. We've been talking about this for a long time. You have the materials. This is about the notes feature on a task in eCourts. So we had a subcommittee meeting back on July 11th. The subcommittee generally agreed with the guidance that was provided. So remember that we decided we were not going to do a formal ethics opinion. Instead, we were going to prepare a guidance that we would give out to the AMC, Conference of DAs, and the Conference of Defenders, I guess. And so the discussion really centered around whether or not the guidance should include any specific examples of language that is permitted or language that is not permitted to be put into the notes feature. So at the end of the meeting, we took a vote, 7 people agreed with the guidance as written, which included specific examples. And then we had 3 members who were not in favor of that. The subcommittee also asked me to include a sentence to the guidance that although the state bar has no authority to make changes to Odyssey, the committee remains concerned that private counsel does not have access to the notes of the task feature. So during all of our subcommittee meetings, we talk about the fact that privately retained counsel and members of the public pro se litigants don't have access to the notes feature in courts. So I'll turn it over to our chair.
Judge Bell.
I would say we had spirited discussion. It was very spirited discussion. It was a very diverse subcommittee in terms of practice areas, and a lot of people had very sincere and serious concerns. And I think we started out, I think, with thinking about a rule change, and then very soon thereafter decided that was not a maybe not rule change, but a ethics opinion, and ultimately came up with the guidance, and everybody thought that was what most people thought was better. We also discovered that there are multiple kinds of notes in Odyssey. There are notes with tasks. When you task something to someone, you can put a note, and that's what I was familiar with because I do that with my case coordinator all the time. We exchange notes about something. And then there are notes you could just put on the file. And so who could see those notes was a big issue about it. And everybody remained concerned that we, like Nicole said, we were in essence discriminating against private counsel in private practice, and those people who are not public defenders who want to court-appointed work, but not public defenders, they could not see the notes feature. And that's why we put that sentence in. But I was very proud of this committee. We worked through our challenges and we're very respectful with each other. And I think the guidance is great and would urge the committee to consider adopting.
All right. Thank you, Judge Bell. So we'll open it up for other subcommittee members. Tom, I know you're doing double duty and want to hear on this 15.
And for those of you who don't know me, my name is Tom Engel. I've been a career prosecutor in North Carolina for over 30 years. And the concern that I have is not with the issuance of the guidance. The concern I have is with the language that is being declared in some form or fashion to be either ex parte and or prejudicial to the administration of justice. Because that's what this language is going to be declared to be going forward. And the reason I say that is because for those of you that are familiar with Odyssey, when the judge clicks on a case, the first thing that pops up is a summary. And on that summary page will list any orders for arrest that have been issued. If there's been a release order established following an arrest, it'll be there. And that has nothing to do with the prosecutor, right? So to declare that when a prosecutor says that a case has been continued 4 times or called and failed 4 times and the person was recently arrested is within the record already, right? And I think the practical implications of that for the administration of justice going forward can be borne out in a couple of different ways. Let me first do it by analogy. Those of you that have ever been to a district court know we used to use these things called shuts, right? And we don't have them anymore. So when I go to court, I pull up the same thing that the judge can pull up with respect to that case. Well, in the old days, if an attorney made a motion to continue and all the judge asked for was the shut, right? Well, the judge would see on the shut what's been written on it in the past. And in some counties, DAs write things on shuts, like call and fail, right? And if there's been a recent arrest in a matter following a call and fail, then that's why it's on the calendar, because he's been served, right? And so the judge would know that just by looking at it. This declares that information, those facts alone. If I were to put them, I'm not saying I would, if I were to ever put them in a note on a task that I sent to the clerk, not to the judge, that would be considered an ex parte communication with the judge. In addition, if I say it in that fashion, that would be considered to be prejudicial to the administration of justice, because I'm somehow trying to persuade the judge within that task. Now, let me stop there. That assumes the judge goes looking for the task. And that brings me back, when I was prosecuted in the Outer Banks one time, Northern Outer Banks, I had a senior district court judge, who was very meticulous. He would go through every shot before court started. Every shot he would go through, including DWIs. And I'm like, I don't know if that's a good idea, right? And so I'm walking in, I say, morning, Your Honor. Morning, Mr. Rankin. You might want to take a look at the affidavit in number 13 on your calendar. And I'm sitting thinking to myself, oh my God. And I'm sitting there thinking, he's probably the only judge in my 30 years that ever went looking for stuff in a case ahead of him. And so the first thing I did when I saw the defense counsel was, hey, the judge did this to me. Okay, I'm telling you now, because it was clearly as far as that. There was a problem with it, and we resolved it according to the interest of justice. Okay, so that's my concern. And my suggestion to the committee was, let's not create language to define it today that is not in context of what could be prejudicial to the administration of justice or ex parte. My recommendation was, let's use language that has already in the past been adjudicated to be prejudicial to the administration of justice, right? Because then we know the parameters of it, right? Because my concern will be is if merely putting factual data into a task note that is not going to go to a judge is going to be viewed by others within the justice system. And I agree, the private bar, excuse my language, got hosed when it came to this program. And I agree with that, right? But I can't fix AOC. The board knows I've been working with it for 30 years, right? And that's probably been the bane of my existence in some respects. But the idea here is, if the prosecutor is not going to be able to put factual data within it, and there are procedures within a judicial district, for example, a person fails to appear in court. Right, we have a procedure within our district that they fill out a motion, right? And they bring the motion to us, and we mark it consent to recalendar up to the judge to strike the order for arrest if it wasn't going, and we then send it back with the individual to the clerk's office. All right. If that's then tasked to the judge, right, and I know in some districts it doesn't go back to the clerk's office to the individual. The DA is the one responding to it directly to the judge. And if the DA is directly responding to that motion to recalendar, and the DA writes down, this case, to call it 4 times, then it was recently arrested. Right? And that doesn't go back to the accused or to counsel. I think that's an ex parte communication. That means the judge can't make an informed decision about a motion that now is being filed, and the response of the prosecutor will be, want to be heard. And that means everybody that's called and failed that wants to file one of those motions, your motions calendar is going to blow up in the confines of the procedure. It will in our district, and we're a rural district, very small. So again, it's not that I oppose the guidance aspect of it. Yeah, I teach for the prosecutor, I teach prosecutors. I've been doing it for over 20 years. Right? And I recently told them about this idea about what we're talking about. And I don't think most prosecutors will ever write anything of this nature. Right? That would be disparaging. But there is examples within our ethics opinions and judicial findings and discipline being upheld by the hearing committee, disciplinary hearing committee, that says, hey, you can't do that. You can't say that. It's disparaging to the administration of justice, right? Because if we declare this language here to be prejudicial to the administration of justice, what you will get from the prosecutors to try to keep the system moving is probably silence. And they won't write anything on any task ever that the judge, when and if it does go to court, they want to know about it. And granted, that would be the right thing to do it. Because you have the accused, you have counsel, you have prosecutor, and you have judge. That's all I'm asking. That's all my request was is, let's use language that's already been adjudicated to be prejudicial to the administration of justice, or circumstances that are in fact ex parte communication that are not within the record, so to speak. This information will be within the record. Thank you.
Thank you. Yes, sir.
I'm Bill Powers, I'm from the great state of Mecklenburg. I'm one of the many, perhaps the majority, who use the term backup. And I had one discouraging conversation, and I'll preface my comments by saying that the one thing that was unanimous was the suggestion that we make it clear, members of this community, that we're not happy with the Hobson situation, because in my mind, respectfully, it's either an ex parte communication and injurious to our profession, or it's not. And what we're dealing with here is, it is, but sorry, that's just how the system works. And so that was something I'm very proud of, that when I said something about it, Bob said something, who's him? That was me. This is an issue where these will mind so different. I love that saying. I respectfully disagree with Tom, and for several different reasons. And some may be that they not understand something, which kind of makes it more poignant for me. I don't know what their portal looks like. I don't know what the judges of offenders. What I do know is I will never see it. And the information that's in there, if it is in the court file, is in the court file. And in my humble opinion, there's no reason whatsoever to have a special section that highlights something that is already in the court file, that a court, while in open court, can open it, make everyone aware of what's going on, as opposed to a highlighted section. And while that information may be entered, that there were 4 oil rigs and things like that, when I had a shut, I didn't just blindly take someone's word or someone who's written on the shut. The county called, we have literally hundreds, if not thousands of people, some of us that, not all of them, some. I would look into the shut. I'm an analog guy. I love visual, but I'm an analog guy. And I would look at the call bills. I would look at the notices for requests. I would look at the subpoenas that finish. And I'd have them ready, organized by the date, so I'd be prepared when the judge asked me about this, to be able to say, respect or not, that's just a typo, that's the glitch. So yes, it is in the court file. It's a summary that's in the court file. And the borrow Tom's analogy, It's like we have a shut, except that one of the essential parties. When we're asked, where's the shut, the answer is, what shut are you talking about? We have no idea. And so the other issue is that, and I don't know if I'm correct on this, but what Tom said was that it wouldn't be fair for him not to be able to put information in that no one else would see. That's not my understanding, that's not my understanding of what we're talking about. There are notes that prosecutors can put in their tasks, just like there are notes the judges have to put in their tasks. There's some conversation about whether or not that was you will allow the case and all of the thing. If I'm wrong on that, I apologize. I don't have that access. What I'm concerned about are notes that are put in where three of the other parties, judge, prosecutor, and official public defender, have access to something I have no access to. Now, I don't see our member from the public defender's office here, Eddie's also met, and Eddie pointed out something I didn't think about. There's no, hey, red flag, this has been added to your file. There's not a Westlaw, don't rely on this law anymore because it's been changed from jeopardized. And so Eddie said, I got, I don't know the number of clients, but let's assume Eddie has 1 million clients. I know that's a bit hyperbolic, but it's somewhat fair. Is Eddie supposed to check every single day on his portal that he has access to, which I don't, and see if the notes are up there by him? Because there's not this information sharing. And so the idea of the subcommittee, and I was one member of it, some people agree, some, and I totally understand the frustration of the attorney's office, and I empathize with them very, very, very much. And you know, I don't know how all the comments are doing. We have survived in Charlotte, doing it. Some good, some bad. We have integrity documents as anybody I've seen. We have an administrative court with special courts that with stuff about the line of somebody else numbers. So I don't know if my ignorance is that this is happening, I don't know about it, or if it's not problematic. My feel this language, one, was very, very well drafted. Two, was thoughtfully drafted to give guidance. And for us in private practice, I always want guidance. Now I know we say the rules and rules of common sense, and that's great. And I sit here and go, I'm doing my best, I'm hoping I'm doing the right thing. But I like guidance. I like when this organization puts things together and says, we have suggestions. This is not an RPC. This isn't a benefit certified letter from the state bar. This may be something in that conversation, which I think the substantive effect has been that we're all doing. This has already been statewide. I dinner with the prosecutor last night, a 30-year prosecutor retirement from this district. And they are talking about it. Karen was talking about the district attorney's meeting. So if our goal here was to make them clarify and to learn and to grow, and then to say, let's watch out for these things. But I don't want to shut down information about the district attorney's office. If they do way more than I do, they control the document. I tell my associates all the time, there's three people you don't want to take off the courtroom. Number one, no. Number two, probably with the judge is the deputy sheriff. And the district attorney's office, I have to work with every single day. And I know how difficult it is to do that outside. And the concern is with times stop us was that it could literally shut down the ability to quickly adjudicate matters or extremely quickly someone support. So I don't know if there's a way we need to clarify, say, yes, it is internal notes and have it right there for it. I don't know if it's fair to say, let's put on the docket so at least some people can see what's in there that we're looking for. I don't disagree with Tom at all, but I think judges look through shows before, and I nicely say, well, not saying you might take a look at it. Well, respectfully, Your Honor, because I don't go one way, I don't go one way, but that we can go in the block. So I very, very much respect competition. I very much emphasize competition. I just respect this or so I would encourage everyone else here to see that, but y'all here. That meeting went so long and went over our time. So I would ask maybe Brian or someone else to say other issues I'm clearly missing and what you're missing altogether. That's not. Yeah,
one moment, I just want to run, yes, you can, but give me 1 second. I just wanted to point out to that point about who all were in attendance, that at our last meeting and other members that were a part of this subcommittee are Kareem Lucy from AOC, Brittany Pinkham from Judicial Standards, Kimberly Overton Spahos from the North Carolina Conference of DA, Adrena Baker Harrell, who's the Chief Public Defender of Chatham and Orange County. They also participated in our last meeting, so we had a wide variety of folks who wanted to, if you all remember, we wanted to make sure that we had a representative from the different entities on this particular issue for sure. And so I think we did a really, really good job of that, and everybody really did participate in the robust discussion that we had. So with that said, yes.
Just thank you for those words. I guess a couple of things that stuck out to me. The notes and the tasks that we're talking about are not on the summary page. When a judge puts into a case. In us. Right? The only thing that gets on that summary page is actually events that the clerk put into the system, either via the return of documents or orders or motions that have been filed into that. So the notes and the tasks are buried within each task. And I venture to say that, at least for the prosecutors that I know, they would never write something like this on task, right? Because it's not going to the judge. It's not going to opposing counsel. It's in reference to a reason that they're sending a task to the clerk to either calendar something or to continue something or reschedule something with the consent of the opposing party. So I think there's that open level of communication already existing in most places, or all places, it should. So the information we're talking about is specific to a task that is not in the general record that is viewable by a judge, but it's rather something that the judge would have to pull up within each task. And there are a lot of tasks going into these things in order to find that record. Well, to find out what's said. And I agree with you. I think it's unfair that private counsel do not have access to what in essence is a show, right? You know, and frankly, I don't know what those people were thinking. I've been on committees with AOC to develop technological issues, technological programs. And that was blatantly obvious from the work that I started looking at this. Somebody would think about these issues. Because I mean, I've been a prosecutor a long time, but I was also in private practice for a couple of years as well. So I mean, it boggles the mind. But suffice it to say that I agree we need to issue the documents. I'm just concerned that if we declare this language, that there's no prior precedent for it to be, in some respects, ex parte and prejudicial to the administration of justice. We're going to open it up to this idea that anybody says in a note is going to be looked upon at some point in time in the future and be reported to the bar in some way in violation of that ex parte communication. That's why I propose using language that previously adjudicated to be prejudicial to the administration of justice, or clear, obvious communication, ex parte communication with the judge.
So if I could, I want to make two points in regards to what you both have said. So first off, and please correct me, Ryan and or Nicole, but we have that language, the specific language in our opinion, not opinion, but our advice, our guidance, because that was the actual language that was brought to us, and we wanted to be sure that we address specifically the inquiry that was brought to us. Okay, so I want to make sure that point's clear. And then I want to speak to that notes, what you just spoke about as far as what the judge sees and how that functions. I know we have quite a few people who are on Odyssey now, have e-courts and quite a bit that don't. So, and I'm still learning because we just started May 1st. So the notes in the task function, while it does not appear on the summary section, when we first open up a file, we as in the judges, when we first see that summary section, there is also a menu of options at the top or included within each file. And so there is a task function in that each particular file in which we can click on, and then I can go into each individual task and see. So let me take it back a step further though. So, or take it back a step. So when someone issues a task, or they send a task, so if the DA sends a task to the clerk and says, hey, I want to put this file on, whatever note in that task. That task note is left on that file forever.
Right.
It's just, I gotta go searching for it if it wasn't tasked to me. So if the DA sends it to the clerk, but the clerk never sends it to me, I may never see that note in that task, that particular task. But once I receive the file, because I know that there might be some stuff, like for instance, I have had instances in which the clerk is like, Judge, do you remember what you told me to do with that particular file? And I'm like, yes, this is what I said to do with that file. And then I say, look, in the task, so they can pull up the task section and they can go back in and they'll see the exact note that I put in that task. So that's just an example. So it is in the file. It's just that you have to know to go searching for it. And that is the public record. So it does get in there, but during the time period when this discussion is going back and forth, meaning the task from person to person in that particular time frame, the other side isn't seen. Because you wouldn't know to go looking, you wouldn't get this ding, this alert saying, hey, there's been a note attached to this particular file. Now that's the note in the task section. Then there is a notes section in each file. That is what I consider to be very similar to when you had the actual shuck and you wrote on the back of the shuck. That would be that kind of note, because that is at the top, it's easy to see, you see notes, and as soon as I click on notes, all the notes that either I as a judge, the clerk, the DA, the defense counsel, you do actually have access to those where you can put notes into that particular section. And I as a judge, if I ever want to include anything in a file, I always put it in that note section and I make it known to everybody right there in front. I never put notes in a file, especially in criminal court. I never put any note in a file that I don't actually say out loud to everybody in front of me, because I'm always concerned about this, especially being on this committee, to make sure that that doesn't happen. So I just wanted to kind of hope that gives people a little bit more information about how that notes and.
I agree.
Mhm.
The original concern was those notes. And the DA's office cannot put anything into the clerk's notes in the file. We have no permission to put anything in the clerk's notes that you just mentioned in the file. Right, the defense attorney doesn't, we don't, only you can ask the clerk to put those notes in there or put it in. I'm not even sure if you can actually put a note in the file. So, and that was the original issue. The original complaint that came to us was that the district attorney put this conduct, this language in a note that went into the clerk's file. And we learned pretty quick that that does not happen. We cannot put a note into the case file, into the clerk's record, so to speak. We don't have that access. We don't have that permission.
So while that is true, it still is in that record. That's why I wanted to make it known to
Right.
everybody.
It's in the
It is
record.
still in the
It's
record
attached
because
to a task.
it's in the task.
Or any task that is sent to the clerk.
Absolutely.
Right.
Yes, go ahead.
We talked about, the Wake County DA was there, and we have a large volume, as you can imagine, I'm not saying this is Mecklenburg, y'all have a large volume too, but, of cases, and when people do, one particular issue that came up was when, if you miss court, you can go down to the clerk's office and pull out a motion, strike, call, and fail. Well, why do you wanna do that? So hopefully you don't get arrested, or get your license revoked. Well, that goes to the DA next, but when it leaves, the defendant gets to write whatever they want to write. Call and fail because I forgot, because I have not, whatever. It then goes to the DA, so now you've heard from the defendant and the DA, and then it comes to the judge. And the judge, can decide, yes, I'm striking, or no, I'm not. So I think that, in my mind, that's different, because everybody has gotten an opportunity to say something about it before it comes to the judge, but those can be viewed, because those forms come to us and it goes to the DA first, after the defendant fills it out, sometimes the DA says no position, and sometimes that's where they might write, call and fail twice before, and when I get those, go back and look at the, history of the case to see, has this defendant filed 5 motions to strike, call and fail, because they never come to court, because I wanna know that when I'm trying to decide to strike it or not.
And Your Honor, thank you, Your Honor. And frankly, that's my concern. If that person comes to my office, I write on that, called bail 4 times, recently arrested in X county. And I don't give that back to that person per se. And then I send it to the judge. I'm sending something to the judge that my opposing person has not no notice of. That's what we're talking about. And that's my concern with the language that's utilized in this context. Now, obviously, Brian and I talked about this, if I start writing disparaging things and things that are not within the record and trying to, make comments about the defendant personally or something like that, clearly that's contrary to the administration of justice, right? As a minister of justice, the prosecutors are. But that, what Judge Bell just said, it kind of encapsulates my concern with using this language that in some sense of the word is factual, right? And relative, if it's included in a note, reference to a motion to continue. But there's nothing new there. I'm not putting anything new into the record. The record exists already, and the judge has access to it by clicking on that case number.
So that was something that I feel like, we get into all the different details of the system and all that kind of stuff, but I think one of the things that struck us when we took a look at this, and when the complaints have come in, and a lot of complaints have come in before we decided to even address this. But it wasn't so much, I guess you can get into some of the substance, you can get into exactly how the mechanics of eCourts work, but it was this notion that there's a communication occurring, and we're looking at how it occurs and kind of maybe an underlying flaw. We talk about this particular language and whether or not it's the equivalent of something you see on the shuck that a judge could put together. To me, this is the equivalent of one of the attorneys taking a sticky note and putting it on the shuck and kind of doing a quick little summary. Hey, defendant has a motion to continue. They got called and failed 4 times before they were recently arrested in this county. That's something that a judge could figure out by looking at the record, perhaps, or it's kind of this question of why do you want to include that? Why do you provide that information? It's because that's part of your argument why the motion should be denied. It would be kind of an equivalent analogy of someone, a defense attorney, putting on the shuck, or maybe if anybody, whether we're talking public defender or private counsel, had access to the system, that they put in their request to calendar a motion to continue. It's something that said, state has received 2, or motion defendants motion to continue, state received 2 continuances for failure of investigating officer to be present. And it's kind of that thing where it's factual. That was why the state got a continuance before, but why are you including that? It's kind of a little bit of the substance of why you think you should have your motion or your desired outcome reached by the judge. And I think that's the thing that we felt like, is this language disparaging? No. Is it factual? Yeah, it probably is. But it's the question of why do you need to say it when you can find out what it is in the record? When it's something that you would say if the 2 litigants were before the court, and they say, Mr. DA, there's a defendant motion to continue, what's your response? Defendant was called and failed 4 times before, and he was recently arrested, so I don't think we need to continue this thing any further, and then defense counsel gets to say their part. I think that was the thing that struck me when shown some examples of task notes in eCourts early on. And I think that's another thing. We're dealing with growing pains here, right? It's a new system and all that. And I think that's while this kind of gets sorted out, the idea behind this guidance is to say, even if it's something that's factual, it's still something that you have to ask, why am I including this? If somebody can discover this, if a judge, a clerk can see this information by looking at the record, why is it necessary to put the task? And if it's unnecessary to put in the task note, then you can understand where others would think, well, you litigant, put that in there, are you trying to get some sort of advantage, some sort of edge, some sort of I guess, set the scene for the judge who's ultimately gonna be ruling on the motion before I have an equal opportunity to also present my side. And that's where I think my concern came from in looking at it, whether it's ex parte, it's only ex parte per this guidance, because or in a situation where defendant is represented by a private defense counsel, because they just don't have access to it. And the definition of ex parte communication is a communication, not factual, not argumentative, it's just communication to a presiding judge about a pending matter. And so this is a weird one, because it is a communication perhaps to a clerk that eventually goes to a judge. You know, I recognize this is a weird situation, and the rules may not cleanly fit with this situation, because clearly if it's directly to the judge, we're in that realm. This is kind of to the clerk or the judge by way of the clerk, perhaps. But that's the only way that ex parte comes in. Otherwise, we're just looking at this question of something that's prejudicial to administration of justice. And in that 2019 FEO4 prior opinion, we talked about, or that opinion discusses communications that are unsolicited by the court that come from the litigants. And some of those communications may be factual, they may be accurate, they may be argumentative, they may be any sorts of things, but it's just kind of this notion of equal access to the courts by the litigants is what the rules are trying to preserve and try to encourage. And so my question for this language is, why does a DA, why does a public defender need to include kind of a summary within the task notes, when all that information can be readily discovered by a judge clicking on a different tab?
So to piggyback off of what Brian is saying, I just want to direct everybody back to the language. The specific language is unsolicited and not authorized by law or court order, and because private counsel will receive no notice of the injury in defendant's online case file, and private counsel does not have reasonably prompt access to the Odyssey online case file to review any potential inclusion or additional commentary. That is what's kind of summarizing everything that Brian has stated. It's that unsolicited portion and all of that other information. It's not that you won't ever get the opportunity to say what you wanted to say in a task note, but just why are you saying it at this particular time period, this particular way, without the other party having access or the opportunity? Yes.
Thank you. You know, I have the same problem that Tom had with this language. And I know my perspective is probably a little different because we don't handle the numbers, I guess, in Superior Court district. However, the phrase for prior OFAs or whatever, I think the committee's looking at that as some form of advocacy by the district attorney in the case, and it's not. In any case, when this is the circumstance, that information is going to be brought to the judge, and everybody's going to have a chance to be heard. It's not. There's no. I would argue that defense attorneys are going to know if their clients have prior. Okay. Because they're going to be in court with, and that's going to be one of the things we're dealing with. I don't have any problem with you deciding that ex parte communications in these notes is inappropriate. This is a bad example because this doesn't give anyone a procedural advantage at all, and it doesn't go to the ultimate issue of the case. This is a factual part of the record, and summarizing it has no value in advocacy at all. It's just a summary, and I don't know why the agents do it. I mean, maybe so they remember when they're going to argue. Maybe that's when they go to look. Say, oh, what points do I need to make this? I don't know. But it doesn't give them an advantage in advocacy. It doesn't harm the defendant because this information is going to come out anyway. And I just think if we're going to do an advisory, we need to do it with some language that has some body, some growth to it. I don't know this, but this is not the language in this case because it's just it doesn't have the impact that I think is being offered has.
Judge, if I could offer this to you, and I think I've mentioned this in the subcommittee meeting, but I would submit that it is advocacy in the sense that it gives that, using the example, the district attorney a little edge up on the argument, making the arguments early. Because if it was just simply the fact that the person was called and failed 4 times, and that was actually true, without any of now, that judge, we would hope that a judge would receive that information and already kind of have it in mind, oh, this person's already been called and failed 4 times. I'm not gonna, they're kind of already thinking of some things, like, I'm probably not gonna grant this continuous again because they've already been called and failed 4 times. And then you have to wait till you get to the courtroom for the defense attorney to say, yes, judge, they may have been called and failed 4 times, but 2 of those times was because of this reason, and this is what happened, or that one call and fail was inaccurate, it shouldn't have gone in and have to explain all of that, but you already have it in your mind, just because they were called and failed 4 times. You get what I'm saying? So that does, in some sense, now that may be a rare example, right? Probably more rare in some counties than others. But that is, in my mind, an example of when that would be some advocacy, getting the edge up on advocacy before everybody is at the table to really make those arguments. Even though it may be factual that in the file is 4 times called and failed, there may be some discrepancies in regards to that particular information. So that is just kind of.
I just don't think a judge is gonna act on that note in that way.
We hope they won't.
Well, I don't think they will.
We hope they
I have a lot of confidence in judges. I don't think that has an advocacy effect.
inherently I do too, but
I just have a clarifying question, as something
Yes.
John and it was done. In that situation where there's a note, and it's possible that the judge could just internalize that note and not bring it up, is that correct? And then the defense attorney would need to know
Exactly.
providing that information for, is that right?
Yes.
Okay,
absolutely. Yeah.
So I think we're also assuming that what's in the file is accurate, which is not always the case, right? So like, let's sort of, people make mistakes, and some people are not good attorneys, right? And some judges aren't good judges. And so when you put things in a file that another attorney does not have access to, and may not, and won't ever have access to, you hope, to your point, that the judge might bring it up, maybe the judge doesn't. But none of the civil attorneys, of which I am, are talking about this right now, in that we could be up in arms if I had a communication that occurred with another attorney on a case that was sent to the judge, and they did not report it. And it ended up in all of our motions and all of our correspondences, even subpoenas, you have to have communication with opposing counsel, and then it goes to the judge. We always have the ability, even a person, to be able to, of course, respond before judges can make a decision. It is wholly unfair for private defense counsel to not have, or per se individuals who don't have an attorney, to not have the same access at the same time contemporaneously when the judge gets it. And so I understand, like, e-courts is garbage. There are so many other issues that I can say that I think that's a piece of shit. But, and I've shared this with the AOC many times, but I think that the reality is that we shouldn't shortcut or change the rules of ethics simply because the system that was built and that is problematic should harm a defendant or counsel in that position. If there's a workaround, great, but I think that all of us private counsel will be furious if we were in a situation where the communications were going to a judge. And we did not know about it until we potentially got to court. But we may never know about it because somehow there's a system that you can't even. And then we're just sitting out here hoping that our clients know it. So, if there's a fix, I say AOC should just take the fix. And we should figure that out. And then we don't have to be in this. But until there is a fix, it seems pretty clear to me based on the conversations that we've had today, that is ex parte. Because it's communication to a judge, whether it's advocacy or not, it's ex parte.
And let me say one other thing, with regard to access, everybody out of terms, that's a hill I'll die on. Okay, I agree with you 100%. The way this thing is put together, it's not right. It goes against all the traditions of our system, and I think it needs to be good. And I'll fight that fight with all of them. My problem strictly with this language is this example. Okay?
Thank you. Judge Bell?
And I feel since our elected DA Awake is not here, that I should speak this on her behalf, because she was in the original meeting and had this concern. In Wake County, like I said earlier, when defendants miss a court date, they can file a motion to strike the call to fail, and that's heard outside of court. And it goes to the DA's office and then it comes to us. Would we find that this would violate if the defendant has gotten a chance to say what they wanna say, and the state has got to say what they wanna say, and then it goes to the judge, and that's a problem? Because both people have spoken, no,
Communication, not, getting received on first.
then I would say this, if we don't allow that, then basically, there will be a whole bunch of people whose licenses get suspended, who get orders for arrest, who, and in Wake County, it's gonna basically come to a screeching halt because of the bond.
We do it all day, every day, and so it's the blue sheet that you can see it running down the hall, you know, they're coming to get a signature, and the DA's already initialed it. And all day, every day.
I think that falls in under the category that there's been an established protocol that you all have in order to deal with that particular issue.
Maybe the judge is local.
So it's outside,
Say
right?
it's a local.
So it's outside of the law. And everybody knows that this is going on. This is an instance where one side does not know at all that these notes and comments are being made.
That disrespect, the local rule doesn't overrule these rules. Right? In other words, in that situation, if I write on that motion, object, call and fail 4 times, just arrested, and I don't give that back to the other side. That's an ex parte communication with the judge.
Unless it's authorized by law. That is one of the exceptions to ex parte. So if there's a local rule that says the litigants may enter into e-courts whatever information they want in the task, then it would not be considered ex parte communication because there's a local rule. So the local rule would permit that type of communication. That's why you have ex parte applications for all sorts of domestic orders and all that kind of stuff, and those are ex parte. However, they are authorized by law, so the rule would not apply.
Yes, sir. We're gonna take this comment and then.
So basically, for these bigger counties, like Wake and Gilbert and Forsyth, when the pro se defendant fills out the motion, will there be something on the motion that they're filling out? I know it's a standard form, that maybe just warns them that, the DA's office is gonna be allowed to, respond to this and give it to the judge, because it looks like it goes to the DA and then the DA gives it to the judges. Under the rules, that be ex parte communication no matter what, doesn't matter if you commit or object, right?
And again, it's one of those things that if the Wake County practice or any other county's practice, if they have an established procedure preferred by local rule, then ex parte communication prohibition does not necessarily apply. Ex parte, the definition of an ex parte communication is all focused on basically communication with the judge, that's outside of the outside the record. It's with the judge and outside the presence of the opposing counsel. But very language of 3.5 is that a lawyer shall not, unless authorized to do so by law or court order, communicate ex parte with the judge. So if there is a law or court order that permits that communication, then we're not dealing with my local
Right. If it's by local rule, we're good. Is that still prejudicial to the administration of justice? Is that way by local rule?
I think that's a great question. I would say, my personal thing is no, because if a judge, that was the whole thing in 2019 FEO4, we're talking about if a judge solicits the information, even if it is not necessarily ex parte, because that was one of the things that the lawyer sends a whole bunch of unsolicited information to the judge, but copies opposing counsel. So it's not ex parte. It's still prejudicial to administration of justice because it was unsolicited. So if the judge says, yes, send it to me, then I don't think it's prejudicial to administration of justice. If there's a rule that authorizes, I don't think it's prejudicial to administration of justice.
So the content of the communication, as you said, is the why. right?
If
That
that's
still
permitted,
may be prejudicial to the administration of justice,
unless it's
even
permitted.
though it may not be necessarily a target.
Yeah, I think unless it's permitted, unless that is one of those things that, whether we're talking unless authorized use by law or order. You know, again, it's one of those that the unsolicited substantive nature is what was prejudicial in 2019.
We'll take one more comment,
That's a question.
question.
So it seems like now we're down to a situation where, there's this, protocol about for defendant, pro se, to ask for, call and fail to be stricken. And that information is going to be it's going to judge, when the judge has a threshold opportunity to either strike the call and fail or not strike the call and fail. Is that right?
There'll be I missed the
There'll be
last.
a hearing on whether or not a person should be called.
Most instances, no, not a hearing, they'll just have to get picked up on that order for arrest and that'll be addressed at that next court date. All of that.
It'll stay in its current status. If the judge takes no action, if it doesn't go to the judge, and the judge takes no action, it stays in that status. And so, let's suppose they miss their court date, they're called and failed, and they're not allowed to do that motion because the DA is not allowed to respond to the motion, and they gotta wait. So they can't get any relief.
Right.
And so if their license gets suspended as a result of that, it's gonna remain suspended until they can pay a lawyer to fill out a motion strike, call and fail, schedule it, get talk to the DA, see if they can get it on a hearing calendar.
So I think this is a little outside going to further out of what we were originally starting with.
Administration of justice.
Gotcha.
It's not your role. The other problem I've got, and I've got a question I would ask is, what if the DA just put opposed? Right? And you got that as a judge in that situation. What difference would that make?
Guess I asked the question, that's why I've been asking the question with all these things. Why do we put it in? Why?
So what if the DA just put, the guy or person says, I want my, call for stricken, I had to, right? And, DA says, I oppose it, and you get that, right? The pro se person has got to say his piece or her piece, the DA says, I oppose it. What difference would that make to a judge in that limited situation where you've got basically an informal procedure to try to reduce your call and fail time, right? But that seems to me to be the gist of it. So if the DA can't say this person has been called and failed 4 times prior to this, all 4 times he had to, which is a response to the, I want it stricken because I had to. Then, but the DA can't say that. All the DA can say is, I oppose it, right? What are you gonna do as a judge?
I think as a judge, I'm gonna wonder why I don't have more information. Because the other side has been able to say, I missed the court date because. And now the state doesn't get to say we're opposed because, to me, that, when both sides get to speak, then you can make an informed decision. It might make me deny everyone so that they all have to come on for a hearing.
So again, I do think this, and I understand it ties in, but not completely as to what's before us right now. In the sense that I think our position is that if there's an established protocol with a local rule that allows for this process that you all have put forth in regards to call and fails, then that still falls within this example that we have. But aside from that, we can have that
Well, they
further
forget
discussion.
like that put into the, guidance. I feel like everybody across the state is gonna be wondering, about unless there's a local rule, put into place or set by local rules, or phrases or practice. That way, you kind of give people the heads up. We're, I'm sure they're.
I like that.
I mean, I guess, yeah, that's a great question.
We can continue to.
Yes, we can. It sounds like, do we have a motion, before us? I mean, I think we were coming postured, hoping to go ahead and push this along as far as giving that advice.
Just, my perspective, I don't, haven't done this kind of work for so long, I didn't really understand what we're talking about.
Gotcha.
So this process that you described is actually beneficial to everyone,
Yes.
right? It seems to be. And if somebody is saying, getting a shot at getting the call and fail stricken before they're arrested, and the DA wants to put on there, these things have been done 4 times before, that doesn't seem outrageous to me. Right? Because in a sense, you're having both sides given the equal opportunity to say that the judge has the information that they see. Right?
I think that's a separate inquiry.
Right.
This one is.
But it's not, but how can it be a separate inquiry if we're making a blanket, pronouncement about an ex parte communication to the judge?
I think this scenario, the facts are different because we're talking about e-courts and the ability of one side to provide the because without any opportunity for the other side to respond to the because or know that a because has been entered.
Which is, this example gives both sides that opportunity, and it's not, it actually is solicited information.
So in this example, isn't this where a motion was filed by the defendant?
Yes, yeah.
Well, in their motion, and they're not stating why they were for arrest to be recalled.
In their motion, again, that's in that record, and I think that's always the question. Do we, in the task section, or the task function, there's a note, and so you could file your motion, that's absolutely fine, everybody can serve with that. The DA could file a response. But I don't know if they're gonna be filing a motion, or a response to that motion. Instead, they calendar it and they put language into the task that is the motion to continue. The defense counsel may not, if they're private, will not see that. If they're a public defender, they could see it, but they don't know that it's there. And so it's kind of a communication that occurs outside the ordinary course. And that's what 2019 FEO 14 or FEO 4 was talking about. The notion of you can file stuff. That's absolutely, that's always been okay. You can argue in front of a judge. That's always been okay. This is kind of a new version of that I guess, informal communication. I don't know if I would say it's akin to defense files a motion to continue and DA texts the judge, defendant called and failed 4 times. I feel like that's probably not the same because it's a different system. That's not what it's designed for, but it's this notion of communication is going from one party to the presiding judicial official. And the other side doesn't know about it, or it does not even have access to it. That's.
And this inquiry was specific to a defendant motion to continue, which is not, and it's not similar to this call and fail where there's an established protocol and policy behind how that communication happens.
The issue is, when consent's not a problem. Yeah. It's what we don't, could you imagine, I as a defense lawyer, have a special note section that you don't have access to, that says, Officer A did in the sheriff. You have no ability to file that, you have no ability to review that, and you don't have the ability until you come to court and say, actually, this kid is in the hospital, it's terrible, the right condition. Could you imagine, therefore, that we would have if we were not to access to the court judge? Could you imagine that? It would be unfathomable. It's not that when we agree, we always do things like the same, but in one of those family laws, we regularly communicate with judges to let them know what we're going to fight and say. Scheduling. Our regulars are the attorneys, yeah, I'm fine. But you have to look at it through the focus of the lens of what our RDC originally says. Like, I can't even tell, but seeing a mass email out to this sort of American County saying, hey, my car broke down. And there's 10 judges on it. You know how many ethics violations that is? That ain't one, it's 10. So the issue isn't having a process by which we can effectively handle FDAs when everyone agrees. It's when we can't agree to something. And then there has to be a union. And we've established a local rule protocol that says, y'all don't put down the individual, if I can consider or not consider, or wants additional information, that's fine. You can submit, just like we do memorandum of law. But the rules even now, if I understand, say, even if I CC opposing counsel on my motion, without giving the DA or other side an opportunity, I'm in fact getting the link up. So I just have to ask my friends, it's like, can you imagine if I file a motion where all you can say is, well, you know, we'll argue about support, and you didn't even know about it. You didn't even know about it. That's what we're going to talk about. It's not really a big
outside the normal course, it's a procedure that they understand. And every, I know, if I know the DA is gonna respond, that's totally different than I don't know the response to the issue, because that's like.
Right. If you file a motion, doesn't create a special task that someone is up there. It's what we going for. That's the difference between filing a motion and a task. If it doesn't have a purpose, then why write it? Why do you have it as a task? Because there's no perspectives on the same, I'm gonna make a move based on what I hear, what I agree. I'm 100% agree. Then why, if it doesn't have a substantive purpose, why?
So I know we need to wrap this up. It sounds like we probably are gonna have a motion to send it back to subcommittee.
Oh, I was gonna make a motion to approve.
Okay.
So I guess.
I would like to.
I'm gonna say that what they're saying is, right, additional language, I can make sure that it's something, not going to super something, there.
I stand by the motion to approve, but if y'all want to send it back to somebody.
All right, let's start with your motion. We got a motion to approve the advice. Do I have a second? All right, motion to send it back to subcommittee. Do I have a second?
I second that.
All right, I have a motion and second to send this inquiry back to subcommittee. All those in favor, please say aye.
Aye.
Any opposed, nay? All right, so we will go back and continue to have our fruitful discussion. All right. Thank you. Thank you, Tom. Do we need to send you with a note while you're late?
I just putting my.
All right.
Thank you, Tom.
All right, we have a lot to get through, folks. I see people moving around as if this is the natural pause. Let's do a 5 minute. That was a lot.
All right, I will just say, I just scratched everything. Yes, there is a summary that you can put in. It's not right, that was right. I'm gonna run to the ladies. Why, really, you got time.
Oh, all right, so there's, I was at. I was at.
agreement requiring payment of estate planning mortgage future legal fees. Everybody has the materials, we trust that you have done a great job of reviewing everything that was submitted prior to the meeting. So it's a great summary already included in the materials. Unless, I don't think, you don't have anything additional to the summary that's already, thank you, Suzanne. So I would ask for a subcommittee member if you have any comments. The agreement requiring payment of estate planning lawyers' future legal fees. Wade Harrison, Tom Lane, Gina. I thought if I had to remind you, you're on this committee. Okay.
Yeah, we're not supposed to be together, but yeah, Suzanne found some excellent language that, was out of South Carolina. And so it looked really good, there was like a meeting on some consensus regarding this, but and personally, I was very pleased. This matter has been dealt with elsewhere, and I like the way that it did it. So those of us, I'm so meeting, because soon once we all schedule training,
Yes.
then we come to consensus and hopefully we bring something back that we can approve.
All right.
I agree with that.
All right, so do I have a motion to return this to subcommittee? Second. Motion and a proper second to return this inquiry to subcommittee. All those in favor, please say aye. Aye. Any opposed? All right, moving right along. Number 3, proposed 2024 FEO 1, use of artificial intelligence in the law practice.
This is the opinion on AI, it's been revised.
All right.
No, I'm kidding.
Y'all like what you said, right?
I'll be very brief on this. Yes, we did get those 2 comments after publication, the subcommittee met, and we discussed the different revisions. You have a track changes version in your materials that shows you the changes. You'll see that they occur in opinion 5. Opinion 5 really is just some additional language that just clarifies the level of independent judgment that lawyer needs to exercise when relying upon or using AI or products of AI. Opinion 6 is really where the changes occurred. This one dealt with what a lawyer can charge as far as their AI expenses. And so the opinion has been revised to clarify that yes, a lawyer can bill client for the expenses that they incur with their use of their AI, including specifically identified and directly related or services that are specifically identified directly related to the legal services that are provided. You know, like you use a particular AI program for one client's matter, that sort of thing. As well as if you have AI costs that are built into a general administrative fee. We do have law firms that charge that general administrative fee, whether you're talking copies, printing, postage, tech-related expenses. Basically, when you use technology to improve services or client convenience, basically available by the cloud and so forth, you charge that administrative fee as long as it's not clearly excessive and the client agrees to it, of course. And that's that can incorporate AI as well. So you see those changes in the opinion. Warren is the chair of the subcommittee. I don't know if you have any comments there.
I have no comment, I move to accept it. Others of the subcommittee may have comments.
Second. So motion to publish. Okay. We have a motion and a second to publish. All those in favor, please say aye. Aye. Any opposed? All right. And moving to inquiry of seven. Obligations related to notice when lawyer leaves a law firm.
I knew that, I had a conversation about word and
Oh, yeah.
Carolina, and I think it's neatly under this topic because it was very restrictive. I thought Judge Ryan's kind of like, you know, when the kid man invented the wheel, he said, well, you can use this, but only the law of, you know, template, and bring it back to the case. And, it's, you know, have some strong opinions about it, but it's really providing use of it just to the products like Lexus.
Yeah.
Texas. Really, you gotta make sure that somebody in your office, if you're making a citation, checks that, make sure it's correct, because you'll remember the story we heard about early in this process where I think it was Texas, submitted a brief
or a memo that cited fictitious cases that are made up. And, anyway, it's only a one-page order, but this kind of sets things back.
Yeah, I'd like to think that our opinion published, well, hopefully it gives a better sort of scope for a lawyer's use of AI. But bottom line is our opinion says lawyer can use AI. It's not restricted to just the known legal research databases and all that stuff. It's what you want to use, but lawyer, what you use, you're responsible for when something. And so I would hope that maybe that order gets changed at some point. But I don't think there's any plan for the state bar to go out and fight with the Western District over their order. We'll leave that to others.
Yeah, I felt like that was more of a Westlaw protection.
Or the vehicle Lexus.
That's what
I'm going to point out that there was a misspelling of Lexus Nexus. Apparently, you're not allowed to use a Lexus car.
They run, they went back, they have handwritten corrections.
Oh, did they?
You to an I, but.
Technology.
All right, so back on inquiry of Savage.
Yeah, this is, an inquiry, it is still in subcommittee. It discusses the various aspects of the notice requirements that come into play when a lawyer leaves one firm to join another. The proposed opinion currently has 8 inquiries. It might ultimately have more. The subcommittee was able to actually do twice since the last meeting, and we have been working, through the 8 inquiries in order that there are opinions. So far, we have been able to get through 6 of the 8 inquiries, and we are hopeful that we will be able to present a proposed opinion.
All right, thank you, Savannah. Ray, you got one of comment, motion?
Really our subcommittee just kind of shoot stuff and roll up the sleeves after the April meeting. Had robust discussions, we've made great progress as they went out and knew there are other things that tackle. But I do want to kind of ask this judicial notice following that we got a pretty robust packet at the April meeting. And I really didn't focus on it until recently about Sheriff Warren. Kudos to the 3 folks on the staff there. His initial inquiry, his first sentence was, really, what's up? Drinking.
That's awesome.
That's a guaranteed way to get us to read your email.
Absolutely. Yes, sir.
Not to extend anything, y'all are hitting all the right issues, and you know, I've got a few and things I'd like to comment on. Don't be next.
Yes, we
Mind if I
Yeah,
know
correct.
about that?
Greg mentioned that we needed to bring him in, so.
That would be great. So, yeah, that's.
Here's your package, included template or a letter, but yeah, maybe there ought to be more than just one.
I know, I agree.
Yes,
And this morning I ate with 2, Dave Breakfast, couple of the council. And they have like 4 or 5, maybe I don't know, 3 or 4, matters right now that they're dealing with grievances filed by ugly breakups of law firms. And, this is good. And I'm right now talking to 3 or 4 law firms, one of them, no, they're not one of those 3 already, with the, ethics, excuse me, grievance, some point too. I don't get it. It's not something that it's something that is good, increasing, occurring that more issues that we can hit to give guidance to these folks. And lose sight of the clock. You know, thank you.
Yes, sir. Is that a motion to send this back to subcommittee? Second. Thank you. Do I have a second? All right, I have a motion and a proper second to send, return this to subcommittee. All those in favor, please say aye. Any opposed, say nay. All right. Inquiry of Hayes, withholding criminal discovery in district court.
Yourself. Okay, this inquiry there was a proposed opinion presented at the last meeting. There was a little bit of discussion, a little bit of unease. I think people thought that it was probably correct, but they just wanted it to go back to subcommittee for some discussion. It involves a criminal case in district court where the defendant is facing a Class H felony drug charge. The DA offers the defendant a deal. If the defendant pleads guilty to a Class I felony, the DA will suggest probation. The defendant wants to pursue a misdemeanor offer, and his defense counsel sends the DA a discovery request. Because there's no legal right to discovery in district court criminal cases, the DA responds and says that if the defendant wants discovery, the DA is going to withdraw his plea offer and seek a conviction on the Class H felony and ask for the maximum punishment. And the issue is whether this plea offer violates the rules of professional conduct. Said a proposed inquiry, a proposed opinion was presented at the last meeting. The first inquiry addresses the DA's professional responsibilities and whether it is permissible for the DA to make the additional plea offer. The opinion concludes that the DA may make this offer as long as the DA is confident that he has complied with his professional responsibilities that are set out in Rule 3.8. As you know, Rule 3.8 requires the DA to refrain from prosecuting a charge that he knows is not supported by probable cause. It also requires the DA to provide defense counsel with any evidence that tends to negate or mitigate the defendant's guilt. This requirement applies even to the district court. The opinion concludes that if the DA has determined that the charge is supported by probable cause and has given the defense counsel any exculpatory evidence, the DA is acting within his discretion in presenting the government. The second inquiry addresses the defense lawyer's professional responsibilities, and the opinion states that defense counsel may participate in the plea offer if defense counsel sufficiently explains the conditions of the plea to his client, including the risk that there might be exculpatory evidence in the undisclosed discovery. The opinion states that defense counsel may presume that the DA is acting in accordance with his ethical duties under Rule 3.8, and the defense counsel may rely on his own client's evaluation of his conduct as it relates to the charges. So there was some general unease at the meeting, and it was at the last ethics meeting, so it was sent to subcommittee. Subcommittee met and discussed the opinion. There was still some ease and feeling that threats was some sort of a threat, and we didn't feel good about that. But we talked about the fact that these types of deals are often offered for good reasons, such as for purposes of expediency, or to protect a confidential informant, or to protect the victim and the victim's family. The subcommittee members agreed that the defendant has the most knowledge of what actually happened, and that conditional plea offers are often in the defendant's best interest. Although some subcommittee members felt that discovery should be allowed in all cases, we realize that that is a legislative issue. The subcommittee members agreed that the opinion is correct as written and should be published.
All right, thank you, Suzanne. Anyone from the subcommittee want to speak on this, make a motion?
So, I'm happy to second her every just in for him. I have to admit that I'm the unease, although you were so gracious, Suzanne, but the unease is sitting with me. I understand where my subcommittee members, where you're coming from. I believe that Suzanne did a fantastic job writing this. I still disagree with inquiry number 2. However, I do feel that legislatively, in order to start going with that, this not doesn't necessarily help us. I can talk about this for a long time. I'm old. I will say that just on face in district court, a Thomas County Career and Child Court. A defendant stood up, his attorney, wanted to reject the offer on the record. The judge asked if all discovery had been, given over in the case. The defense attorney said no, they got a felony report, but they're still waiting on all audio and video. The judge would not accept the rejection on the record because he felt that the defendant didn't have enough information to make an informed decision. I still stand by that, that is the standard in our counties, but that does come from local courts. And I still have a major hesitance with opinion number two, because I think that while the prosecutor is acting in good faith, it puts the defense counsel in a really tough position to be able to rise to compliance. However, all that being said, I think we have a really good, so I appreciate it. I haven't changed mine, but I understand that this is probably the right answer. And I do have,
So I have a motion and a proper second to that motion to publish. Any other discussion from other subcommittees? Or anybody?
As a prosecutor, I thought it was uneasy to practice. I didn't like the practice like that. I always look to tackle the song may not be there next time, rather than but I don't think there's any in this practice that is beneficial for the parties.
Thank you. Anybody else? All right, all those in favor of publishing, please say aye.
Aye.
Any opposed? All right. That motion passes. So next we, for reconsideration of prior inquiries, we have an inquiry of DRC negotiating the licensor reporting capability during mediation. And I understand there was some things, some full opinion was pulled, and so we're gonna Brian speak to that.
Yeah, so this opinion came from inquiry from the Dispute Resolution Commission about a lawyer's responsibility while acting as a mediator, a certified mediator, and hearing litigants discuss I guess a term of their agreement that was not permitted by the rules, namely that, you know, basically we're gonna include an agreement or some sort of term in our proposed settlement that says lawyers or anyone else involved in this case can't report another lawyer to the state bar. That's something that we have ethics opinions on. It says you can't do that. You can't undermine the notion of a self-regulating profession by agreeing to essentially negotiate away your responsibility to report misconduct. So we had this opinion drafted. It was voted for publication, and after the meeting, I received an email from the executive director of the Dispute Resolution Commission that basically pointed out some, I guess, some questions and what she thought were some errors in the opinion. And looking at her suggestions, I thought, you know, these things do need to be addressed before publication. I don't think we ever have any interest in publishing something, getting it on that track that we already know is going to need to be changed. So the opinion was pulled and not published this past quarter. You have in your materials basically a revised version of the opinion, as well as some proposed changes from the Dispute Resolution Commission. I think this one should go to subcommittee for discussion. I think that was staff recommendation last quarter because there are some complexities there of how rules of professional conduct interact with the standards for mediators. And so it's our recommendation that this be sent to subcommittee to have that discussion, particularly to invite some folks from the Dispute Resolution Commission to participate in that, so we can hopefully arrive at consensus on how lawyers are supposed to conduct themselves when they are subject to both rules of professional conduct and the mediation standards.
Did anybody from?
Warren's the only person that's
Yeah.
on it. We never put a subcommittee together,
Right.
but.
Oh, I'm on that.
Well, you're not on this, you were listed as somebody to.
All right, do I have a motion to send this to subcommittee?
So moved.
Second. All right, I have a motion and second to send this to subcommittee. All those in favor, please say aye. Any opposed? Nay. All right, that's separate. We don't have any new increases, right? Are those still the case? All right, ethics advisories, EA 2024-1, inquiry of constant, short-term, limited legal service programs.
So this was a request that we received from Legal Aid regarding 2 programs where they use volunteer lawyers to provide free short-term limited legal services to low-income clients. They have a courthouse clinic, and then they also have a telephone advice workshop. And the question is whether or not these programs fall under Rule 6.5 for short-term legal services, wherein the volunteer lawyer would not have to conduct a conflict check before they provided the limited legal service. So Rule 6.5 prevents a lawyer to provide short-term legal services through a nonprofit organization or a court. It is only subject to Rule 1.7 on concurrent client conflicts and 1.9 duties to former client conflicts, only if the lawyer knows that the representation of the client involves a conflict of interest. So the volunteer lawyer would have to recognize that the person that they're talking to is adverse to his or her own client. And then the rule also says that if you're another lawyer in your office that represents the opposing side, then that conflict is imputed to you if you know about it. So it's based on if you are already aware that there is a conflict, then you cannot provide the volunteer service. Short-term legal service has not previously been defined by the ethics rules or the opinions. So I did some research and found a good definition from a New York opinion. It is defined to mean the provision of legal advice or representation free of charge as a result of a qualified legal service program with no expectation that assistance will continue beyond what is necessary to complete an initial consultation, representation, or court appearance. And so that definition really does fit well with what the requirements are under Rule 6.5. The EA provides that a volunteer lawyer providing a brief one-time appearance in court through Legal Aid's courthouse clinic is a short-term legal service and does not require the volunteer lawyer to conduct a conflict check unless the lawyer knows that the representation of the volunteer client involves a conflict of interest. The same is true for the telephone advice workshop. With the Legal Aid telephone advice workshop, sometimes the volunteer lawyer will prepare a letter that confirms the advice that was provided on the telephone. Usually the expectation is that that letter will be written the same day, but there are instances where the lawyer cannot write the letter until the next day. So the question is that a continuation of the limited legal service? The EA provides yes, provided that the contents of the letter is limited or restricted to a confirmation of the telephone conversation. However, if additional services are required, such as a court appearance at a later date, then that subsequent legal service does not qualify as a short-term legal service under the rule, and the volunteer lawyer would thereafter have to conduct a conflict check to see whether or not he can continue with the volunteer service.
All right, thank you. So, is there anybody else from that? Mr. Derek, you want to give some impressions on that?
Well, after reading through it, it seems to me that the type of programs that Legal Aid are referring to, they fit within that category. I mean, it's just not possible. If you're going to be in the courthouse, for a couple hours, and you're there volunteering and trying to assist, you're not going to be able to do a conflict check. And I'm probably in the majority of those situations. If you're volunteering with these Legal Aid clients, you're probably not going to have a conflict anyway. I mean, we can, obviously, but I don't see that is being a big issue. And especially if it's one issue here in court for an eviction, they're trying to just give them some advice before they go, in front of the magistrate or something like that. I don't think that there's anything wrong with, being able to provide them that advice, that short-term service, and put these conflict check first. I don't think there's any issue with that. And as I said, I think it fits nicely. That's things that were anticipated by us. So I really want to think that this, advisory, is correct, President.
Yes.
I just wanted to comment that legal aid is always struggling to find lawyers to do these types of things. I appreciate that. We're not making it more difficult for voluntary lawyers to participate.
I was gonna say, in court, we have lawyers all the time with their paid clients. And they will say, Judge, do you want me to be a friend to the court? And yes, please, and they'll step over and say something to the person clearly as a volunteer, to give them more information that I can't say, and we can still get matters handled. So I definitely don't want to do anything that would discourage people from doing that. And it's valuable.
Yeah, I've been a friend to the court a number of times, so yeah, that.
We have a lot of lawyers who do that. They're handling their client's case and they hear that the person is struggling with something. They say, Judge, can you give me a minute? I'd be glad to be a friend to the court. Yes, take as much time as you need.
All right, other discussion, comments, questions? All right, do I have a motion? So, yes. All right, we have a motion to approve and a proper second. All those in favor, please say aye.
Aye.
Any opposed? Okay. All right. So. Thank you for that. Now, approval for transmission to council, proposed 2023 formal ethics opinion 3, installation of third parties, self-service kiosk for the lawyer's office and inclusion of lawyer in third parties advertising efforts.
Just the worst title, I think. You've ever put. No, this was published after the April meeting. It received no comment. So it'd be staff's recommendation approved, or to be sent over to the council for adoption.
It's long.
So,
So, have a motion and a proper second for it to be sent to the council for adoption. All those in favor, say aye. Aye. Any opposed, nay? All right. Chair, I'll let you know. If you're about to shut it down. Motion to adjourn. And I'll let you this, we got through our full agenda, so you all have a great remainder of your day.
Good job.
Pretty good.
Y'all. Good burn, team Yes, that's perfect.
All of the works back out.